Hello, I'm attorney Vince Davis. Today, we're taking a comprehensive look at the major changes coming to California criminal law in 2025. It is a critical time for every resident to understand their rights and the new rules of the road. For the last decade, California focused heavily on criminal justice reform. However, in 2025, we are seeing a significant pivot towards stricter enforcement and much harsher penalties for specific crimes across the state. These changes are largely driven by rising public concern over organized retail theft and the devastating fentanyl crisis. Legislators and voters are demanding more aggressive tools to keep our communities safe. The headline change is Proposition 36. This landmark measure, which passed with overwhelming support, took effect in December 2024 and fundamentally alters how we handle repetitive theft and drug offenses. Prop 36 partially rolls back the provisions of Prop 47. Specifically, it allows certain crimes that were previously categorized as misdemeanors to be charged as felonies once again under specific conditions. Under the new three strikes rule for petty theft, shoplifting items worth less than $950 can be a felony if the defendant has 2 or more prior theft-related convictions on their record. Drug possession is also seeing a major shift. A third drug conviction can now result in a treatment-mandated felony. This means the court requires you to complete a professional drug or mental health program. Completion of the program can lead to a dismissal of charges, but failure to comply is serious. If you do not finish the mandated treatment, you could face up to 3 years in a state prison facility. The fentanyl crisis has also led to the implementation of a Watson warning for drug dealers. Similar to DUI cases, this is a formal legal notice delivered by the court during a conviction. This warning explicitly states that if you continue to sell or provide hard drugs like fentanyl and a person dies as a result, you can be charged with murder. It is a very serious escalation in legal liability. In addition to Prop 36, Governor Newsom signed a package of 10 new bills specifically targeting organized retail theft. These laws give law enforcement and prosecutors aggressive new tools to combat shoplifting rings. One of the most powerful tools is the ability to stack or aggregate the value of stolen goods. Prosecutors can now combine thefts from different victims or counties to reach the felony threshold of $950. This effectively closes a major loophole that professional theft rings used for years, committing smaller thefts in multiple jurisdictions to stay below the felony level. Those days are over in California. Simply possessing over $950 worth of stolen goods with the intent to resell them is now a standalone felony charge. Prosecutors no longer have to prove you personally stole the items. Police also have expanded arrest authority. Officers can now arrest a suspect for shoplifting based on probable cause, even if the officer did not witness the crime as it was happening. By relying on witness statements and video evidence, law enforcement can now act more quickly to detain suspects on the scene. This is a major change from previous requirements for on-site witness. Courts also have a new tool, retail theft restraining orders. A judge can now ban a convicted individual from entering specific stores or even entire retail chains for up to 2 full years. Shifting gears to DUI, California continues to have some of the strictest standards in the country. There is currently significant legislative momentum to lower the legal limit even further. While the standard limit is .08, lawmakers are pushing to lower the per se limit to .05. This would align California with much stricter international standards for road safety. For repeat offenders, the penalties are increasing. As of 2025, fourth-time DUI offenders face a mandatory installation of an ignition interlock device in their vehicle for a period of 3 years. Firearm laws are also becoming more complex. One major update is the elimination of the private party exemption for the 1 gun per 30 days purchase rule for most California residents. Prop 36 also impacts firearm sentencing. Being found in possession of both fentanyl and a firearm now triggers much harsher sentencing enhancements than we have seen in the past. Courts must now consider social media activity and digital threats when deciding on gun violence restraining orders. This allows for red flag interventions based on behavior documented online. Understanding the criminal process is just as important as knowing the laws. A typical case starts with the arraignment, which must usually happen within 48 business hours of an arrest. At the arraignment, you are formally told of the charges against you and you enter your initial plea. This is a critical stage where having experienced legal representation is absolutely essential. A new race-blind charging process is now in effect for many agencies. Prosecutors must first review redacted reports to make charging decisions based purely on the evidence and facts. By removing names and race-identifying information during the initial review, the goal is to ensure a fairer and more equitable system for every person who enters the California court system. We are also seeing an expansion of mental health diversion programs. More conditions are now eligible, allowing certain defendants to receive treatment instead of a traditional criminal conviction. The California Racial Justice Act is also now retroactive for many felony convictions entered after 2015. This provides a way to challenge past convictions if racial bias was a factor in the case. Finally, laws targeting street takeovers and sideshows have been significantly strengthened. Law enforcement now has a greater ability to impound vehicles for longer periods and issue much higher fines. California's criminal laws are more complex than ever. If you or a loved one are facing charges, you need an advocate who stays on the cutting edge of these changes. Experience matters now more than ever. Don't wait. Call us today at 888-888-6582 for a consultation. Again, that's 888-888-6582. We are here to help you navigate these complex new laws.